still go after your personal assets. These are the things that you want to do to make sure that they don't do that. One, I mentioned before, commingling. Don't have the same bank account for your business. Get a separate checking account, get a separate banking account, get the funds separate. That's a really easy thing to do. Don't use company assets for personal use. If you do that, you're really jeopardizing the entire value of this limited liability entity, so that's a big one to watch out for. The other stuff is just, when you're entering into contracts, be sure that you're entering into these contracts in the name of this company. You've spent so much energy trying to form. So if you sign something, it's as simple as be sure you sign as the name of the company. Don't sign just your own personal name at the bottom of it, because then how's the person you're dealing with supposed to know that they're actually dealing with a corporation, not with you individually? And that's just as simple as this. Put name of company, by your name, CEO. That's something that people mess up an awful lot, and it can cause problems later on. The other thing, if you do have one of these corporations, record minutes. Record notes when you're talking with your co-founder. Just note what's been approved and what hasn't. In most of these entities, there's some corporate governance structures that are set up so that this type of decision requires both founders to approve, one of the founders to approve, two of the three of the five. To the extent that you've got these kind of regulations and you approve something according to them, write it down, make an email, do something so that if someone disagrees later on, you can actually go back and go trace it. And then there are some tax forms and state forms that you need to fill in. They should mail them to you. Just pay attention to your mailbox and make sure you go after them. It's not hard to keep the corporation solid. It's not a very high hurdle, but it is something that you need to pay attention to. And I never cease to be surprised at how often people mess it up, just because they get distracted by other things, and they keep all the files, all the contracts, all the receipts in the shoebox. At the end of the year, your accountant's going to tell you the same thing, frankly. So it's good advice. There's business licenses and form qualifications that you also need to do. The other big issue that I run into is intellectual property. Most startups, especially these days, all have some intellectual property component to them because they're software or they're an idea, there's a patent, there's some new innovation. You need to be this is the asset of your company. This is the keystone that you're building your entire company on, right? So be sure you protect it. Be sure that the company owns it. The main categories of these things are patents, copyrights, and trademarks. Patents, which I assume everyone has heard of, is a nationally chartered right to prevent someone else from manufacturing your idea. That's the long way of saying it. The ramification of it is, if you get a patent on something, you're the only one that can go out and market and commercialize it. It's hard to get patents, they're expensive. They have to be unique and novel and a new idea, but they're really valuable when you get them. And it's something that you can build an entire company around. Copyright is anything that you write down, paint, or reduce to a tangible medium. So all of the notes that you're taking right now, those are your personal copyrights. All of your doodles that you write in class, or that you do your artwork at home, that's a personal copyright. Your photographs are personal copyrights. Your software code is a copyright. So that's the body of law that covers all of that. And the good thing about a copyright is it attaches the moment that you reduce it to a tangible medium. So again, literally the notes that you're taking right now are your own personal copyright. And that means that you've got a right to commercialize those. The right is not as broad as a patent because it's literally limited to the code that you're writing down right now, your notes. So not that many people are going to care about copying your notes, but if they do, you've got a right to prevent them from making any money off of it. Trademarks are your brand names, and that is the mark that's in the public that people identify your brand with. So Procter & Gamble is a brand of that company, including all of their various products. Crest, Coca-Cola is obviously one of the best. McDonald's are probably the most valuable trademarks in the world because if you see the outline of a Coke bottle, that's one of the trademarks. Why? Because if you see it, you know that that's Coca-Cola. There's no mistaking what that outline means. And there are various ways to protect these. There are national filings that you can do. keep up with and be sure that you're protected. The best way to protect these things, and the place where most people screw up, is to make sure that the company actually owns the intellectual property that's being generated by its employees. And that just means your business, you hire someone, they're coding for you, they're designing a web layout, they're designing a trademark. How do you know that your business owns that idea rather than the people, your employee, or the people that you've hired to design it for you? Well, number one way to do it is to do it through either an invention assignment agreement or a work for hire agreement, which is a contract with your employee or your consultant that says, hey, that stuff that you're making for me, yeah, that's mine. Pretty simple concept. There are other there are other rights that you can claim even if you don't get a specific contract that says, hey, I own this between various people, but they're not as good, and it's really, really easy to get these. It's very, very normal. Everyone expects them. So, right off the bat, if you're starting a business, make sure everyone who's designing code for you, who's doing a product, who's doing development, who's creating any type of intellectual property, make sure you have an agreement with them, even if it's an email that says, I understand that you're creating something for my company, and you agree that my company owns this. People screw that up all the time, and it's really expensive to go fix after the fact, when after the fact you've already proven that this is a really valuable piece of intellectual property that they've gone out and gone and created. And and this literally happens where someone goes out, they write some code, they create a program for someone, the company goes out, commercializes it, proves the market, doesn't have the code locked up, and either one of two things happens. One, the designer comes back and says, wow, I really like what you've done with my code. Now can we talk about my royalty rates or my, that I'm going to get from everything that you're doing with my code? And the company, which thought it owned this stuff, now has to write a really big check back to the true copyright owner. Or the other thing that happens is they say, wow, I really like what you've done for business. I've got this exact same code as well, and I'm going to go out and compete directly with you. And neither one of those is a great situation to be in for the company who probably paid for that code to be designed in the first place. Non-disclosure agreements, license agreements, trademark filings are other just ways to protect, protect intellectual property. Non-disclosure agreement basically says, I'm going to share some information with you. You promise not to disclose it to anyone else. License agreements are what you do when you actually need to license intellectual property from someone else or license your own intellectual property out. And those are going to govern the scope and the rules associated with them. Lock down the IP. I mean, if you guys walk out of this class knowing nothing else, remember that you need to get an invention assignment agreement from every employee of your business. Like, that is a pain in the ass to clean up later, and it's really hard to do because it is almost always after the IP has been proven to be valuable, and it costs you a heck of a lot more to get the IP back when someone does this or something than at the beginning when it's really questionable as to whether or not it'll ever be able to be commercialized. So, let me talk about some of the consequences. Other areas that I see when you start up a business, a lot of times when you start up a business, you don't just stop everything all at once, wake up the next morning and say, yay, it is day one of my brand new business. A lot of times it's a lot more gradual. A lot of you guys said at some point in the future you want to go work for a startup. Well, you're probably not working for a startup right now then, and you may get a job before you go work for a startup, and you may spend some time sort of looking at 3 or 4 different startups before you actually go work for one. You may actually intern for one for a little while. So it's not always this clear-cut process of day one, you start with a startup, day one, you start your new business. And a lot of times what it is you have an idea that's circulating in the back of your mind for a long time that you may start to create while you're working for someone else. Well, if someone else is smart and they've heard my speech before, they made you sign up to an intellectual property assignment agreement when you started to work for them. So now you got a little bit of an issue, right? You want to start working on your new business, but you're under this agreement that says, hey, wait a second, everything that I'm doing for my current employer, they own right now. So how do you balance those issues? Well, the number one way to do it is do something completely different than what your current employer's doing. And do it at home, or on the weekend, do it on a separate computer, do it on a completely separate assets than everything else in your current employers do it, that your current employer uses, so that when and if that employer ever comes back to you and says, hey, this is a great idea, surely this was invented while you were working for me, and as you know, you signed an assignment agreement that says everything that you do while you're working for me, I own. You can immediately respond and say, wow, that's a really good point. However, I can prove to you, because I've kept careful notes, that I designed this idea at home on my separate computer when I was not working for you. And then the business will say, oh, you're right. Well, best of luck in your future endeavors, and can I invest in your new company? That's a great idea. That's the way it always happens. You know, so that's the way to do it, but it's just something to be cognizant of, and it's something that people have to balance, and there's frankly not a really great answer short of quitting your current job, starting all new assets, and building your company from scratch. But that's not always the most practical answer, so the best thing you can do is just try to keep them as separate as possible. The other thing that may be happening, if a lot of you guys are programmers or consultants, you may be working for 6 or 7 startups at once, or you may have 3 or 4 startups that you're developing all on your own. You got to be sure to keep separate which assets belong to which startup. You may have, if you have 3 or 4 invention assignment agreements that say everything that you do while working for us is owned by the company, and you happen to be working on 3 things at once, then you have 3 separate companies that all think they own the same thing. How do you resolve that? Keep good notes. Try to keep things as separate as possible. You can use separate notepads. You have different work location for each business. Use that. Do anything you can to draw up dividing lines between the various businesses. Other IP issues I see a lot. Watch out for open source code. The open source movement has gotten a lot better in recent years. A lot of the new licenses are not quite as aggressive as some of the early ones. But if you happen to be dealing with one of the old pieces of open source, especially, a lot of the licenses that you're using that open source code says anything that you create with this open source code is also open source, which is going to effectively prevent you from ever commercializing or using that code that you just created. So that's something else to keep an eye out on. A lot of the new open source licenses are a little bit better about that, but it's still a problem that shows up. And then I think the other situation I see very often is you have your buddy who's a good programmer come in and you want to bounce some ideas off of them, or you have a friend that's a designer and they're going to help you with your logo, and they come in and really sort of sketch out some stuff and you want to use it. And they're doing you a favor, so it's really tough to kind of put an invention assignment agreement in front of them. And you're not paying them, so you don't want to put a consulting agreement in front of them. But as a company, you still got to be wary of this because, again, what just happened was the person who's doing you a favor is really creating their own copyright. And they're letting you use it. And if you're ever not friends in the future, then maybe they come back to you and say, I know you thought I was going to do that for free, but, I'm not going to, and now I want a royalty for your use of my logo, or you have to quit using it. And at this point, you may have actually developed an entire brand around it, or the code may be fully integrated into your business at this point. It would be really tough to go back and rewrite it. So, that's something to be wary of. I would say, and what I advise most of my clients to do is get at least get something on a napkin, an email, something that says, I acknowledge that I am working with you on this project. Try to identify what it is and say, and by the way, you can use this however you want to. I'm never going to come back to you for a royalty. This is, either you own it or you have the right to use it for forever. Something to that effect is at least going to give you a little bit of an argument if they ever try to come back later and say something. So those are just some of the common problems.
Before you leave that, we talked about corporate entrepreneurship, and a lot of them will go to work for companies, and again, some companies are encouraging them to come up with new ideas and really go to it. And at what point do they need to say, as I'm coming up with these ideas, they could actually become an outsource for them and go